that said, Catherine today is going to talk about family law in the state of Texas. So certainly if you are not in Texas, feel free to stay on the call, but she's only going to be able to speak about the laws in Texas. Nothing in the group today is meant to be legal advice, for sure. None of it is meant to be investing advice. That's true for all of our meetings, and we've never had a problem with that, but I still kind of feel compelled to say that at the beginning of every meeting. Our group is organized by volunteers, and we rely on volunteers to lead our topic. This really super important topic, the 4 times we've done it, it's been either Catherine Benouis or attorneys who work at Benouis Law. So I just want to say thank you to her right off the bat that they donate their time to come and share this information with us every year. Spend several hours with us to just give us this really important information, and we rely on volunteers to do that. So I just wanted to say thank you right off the bat. Let's see, I think that maybe with that, we can get started. Just to let everybody know who's new on the call, just for one more time, if you have questions as we go along, put your questions in the chat box, and Gwen and I will compile them and stop Catherine so that she can address the questions as we go. So please use the chat box. We are recording this, so if you know someone who wasn't able to attend today, but would find the information useful, we will push out the video to us Women's Investing Group members later on this month. And I think without further ado, I will turn it over to Catherine Benouis. So I'm going to go ahead and unmute you, Catherine, and let you introduce yourself and what you do and kind of launch into what you were hoping to talk about today.
Well, hi, everybody. I'm really happy to be here. Thank you for having me. Sarah, always really happy to volunteer to do this. My name is Catherine Benouis. My law firm is Benouis Law. I'm speaking to you from my home office where I've been since March, even though I still have a physical office. I've done lots and lots of Zoom hearings and meetings and mediations and so forth. If people are here from out of state, yes, I only practice family law in Texas, but hopefully some of the material will give you things to think about or give you things to check out in your state. So I've been a lawyer for 30 years, which I cannot believe, but I have been. And I've done exclusively family law for 26 of those. Family law generally, most of my practice is in divorce, but it also involves some other areas like child custody modification, prenups and postnups, and things like that. But I'm going to focus my talk on the financial aspects of divorce and prenups and postnups, because I think that is probably what's most pertinent to this group. As Sarah said, as I'm going through the topics, I know it can't be as conversational as it would be if we were in person, but please send your questions and I'll do my best to cover as many topics as you all want me to cover. One of the things I really want to impress upon this group is that when I see people come into my office for a divorce, they're often learning for the first time about the different rules about property that really would have probably helped them before they got married. It's really hard when people are getting married to try to think through, if this doesn't work out, how would I protect my finances? But especially when I talk to you about the distinctions between community property and separate property, I hope people will take this to heart. Tell your daughters, tell your sisters, because it's not a great thing to find out 10 or 15 years into a marriage that something you thought you had, you are not going to have. I will tell you, and I hope it'll become more clear as we talk, but one thing you can do that's very simple to protect yourselves is really good record keeping. And that means keeping statements financial institutions are not keeping statements like they used to, and of course people aren't keeping statements like they used to. But if you can keep your statements, should something happen in the future, just that simple record keeping can really help. I was talking with Sarah before this, and I've actually had members of this group after my talk last year contact me, call me, or come see me, and they were able really to avoid a premarital agreement just by doing good record keeping. So that's really important. Also, just a really basic thing about marriage. So to end up in a divorce process, obviously you need to be married. And so in Texas, that's a ceremonial marriage, which is what most people are familiar with. But you can also be just as legally married if you are common law married. So I want to tell the group what a common law marriage is. People have a lot of misperceptions about it. So in Texas, to have a common law marriage, you have to both intend to be married. So you have to, at that time, intend to be husband and wife, or wife and wife, or husband and husband with each other right then. Then you have to cohabitate, and it can be for any amount of time. It doesn't have to be for 7 years or 3 years. It could be for a week. And then this is the most important component. You hold yourself out to people in public as married. So that's calling each other husband and wife. The best evidence of that usually is something like you file a joint tax return, or you acquire real property together. But I just wanted everybody to know that if you meet those requirements, you're as legally married as any other way that people get married. Okay. So really the basics. Texas is a community property state, and a lot of people think that what that means is that when you get divorced, everything's divided in half, and that is not what it means. So the first thing in Texas that happens is distinguishing between what is someone's separate property and what is someone's community property. It's only community property that can be divided on divorce. So there's also a legal presumption that everything is community property, and that is what is going to be divided. But if someone has separate property, they have the burden of proof to prove that this is my separate property. So for example, if you are not married and you're planning on getting married and you do have a separate investment account, that investment account that you own before marriage is your separate property. So I want people to understand the distinction, because there are many things people do that end up having the effect of not protecting your separate property. And I am thankfully seeing more women who are in the workforce, have careers, have accumulated assets and investment accounts. You know, they've bought houses, they have a retirement account, they have IRAs, and they're going into marriage maybe even a little older, and don't know the difference between community and separate property. So in Texas, there are 3 estates. There's each spouse's separate estate, and then there's the community estate. So mostly what is your separate property is anything that you acquired before marriage. And that could be, you know, your dining room table, or any of your financial accounts, or a house that you purchased. And then anything that you acquire at any time as a gift or inheritance. So that doesn't have to be pre-marriage. And then anything that you acquired as the result of a personal injury settlement, but not for lost wages. So the other thing about community and separate property is that the moment you become married, your earnings and your spouse's earnings become community property. So often what happens inadvertently is that a person will have separate property or a separate property financial account, they'll get married. Now their earnings are community property, and they'll continue to contribute, for example, to a 401k or to an investment account. And what you've done at that point is what's called commingling. So when financial accounts are commingled, at the point of divorce, it can be very difficult and sometimes impossible to trace out your separate property. So I often have people come to my office. It's a very common scenario. And they'll say, well, I had this account before marriage. And I'll say, well, then what did you do after marriage? And after marriage, people are depositing their paychecks. Maybe their new spouse is depositing their paycheck. And the money is the term is called hopelessly commingled, that we can't separate it out. So if you want to avoid that situation, one of the simplest things you can do is keep good records of what you did have before marriage. Some people, I'm seeing this more and more, are addressing this with premarital agreements and, believe it or not, post-marital agreements, which I'm going to talk about in more detail in a moment. So my point with this is that it is very upsetting to a lot of people when they come in and they're going through a divorce, which is also one of the least fun times of their life that they've ever had, and they're finding out for the first time about community versus separate property. So it's something I encourage all women to just be aware of going forward. And like I said, tell your daughters, etc. The other thing I see a lot of that can happen is someone marries someone with a lot of separate property, and their spouse has done a good job of preserving their separate property and not commingling it with community funds. So I'll have people come in and they're married to a very wealthy spouse, or a spouse that comes from a family with a lot of money. And I often see that they don't contribute to their 401k or other retirement accounts, because in that family, it's just presumed that your retirement is handled because you're going to inherit. And people are also very upset to find out that their spouse's separate property is not there to divide in a divorce. So it cuts both ways. So there's preserving your separate property, and I think there's also being aware of the effect of your spouse having separate property. That is not, if it's been preserved, it's not going to be there to be divided. So if you've been, I've had this happen, someone's been married 20, 25 years, they've not been contributing to a retirement account, they're going through a divorce, and they've really had a lot of financial wealth as they've gone through their marriage. Now it's time to get divorced, and they learn, are you serious? The money that my wife inherited that's in this account is not something that I'm going to have any part of. And the answer is no, unless it happens by agreement. Any questions right now, Sarah, about community or separate property and distinguishing it or preserving it?
I'm going to take a minute here for everyone, because I know that community and separate property for a lot of people on the call might be a very new concept, right? And so if you have questions, even if you want Catherine to kind of go through it again, please go ahead and put your questions in the chat box, because especially if it's your first time hearing these concepts, it might not be clear exactly what she's talking about. We do have a question on record keeping. Do electronic statements count for record keeping? Maybe you could talk a little bit more about, if it came down, to this proving something is your separate property, what types of records are adequate?
Sure, and I'll reiterate what Sarah said. If what I'm saying isn't landing or I need to go over it in more detail, please let me know. Yes, electronic records count. In fact, that's almost all we have anymore. I think it's been years since I had a client come in with a box of their paper statements. So yes, you can just, go online, keep a folder, and put your electronic statements somewhere. So I did talk about commingling, which is when you take separate money or separate property or community money and you combine it in a way that makes it difficult to figure out what was what. The other important thing about this is to know that income from separate property is community, okay? As distinguished from increase in value. So, for example, if you think about a house, that's, I think, the most concrete way to explain this. Let's say you've purchased a house before marriage. That makes the house your separate property. 10 years later, you're going through a divorce and the house has doubled in value. That increase in value remains separate. And so that also, I'm going to take this house example and talk about investment accounts as well. But let's say you have that same house that you purchased before marriage. You and your spouse buy a different house and live in it, and you rent out your separate property house. The rental income from the house is community money. So a lot of times, both ways. Sometimes people think, oh, I bought a house, it's worth a lot more now, that probably should be divided, and that's not the case. Or people think, I have a separate property house, I rent it out, that money is mine, and it's actually community money. So with your investment accounts, as you know, sometimes in those accounts, for example, if you have a stock split, that's going to be considered an increase in value, or or the stocks do just increase in value. That remains separate. But the dividend income that is thrown off and reinvested in the account is community. So at the point of divorce, it can cause some issues in terms of tracing that out. Back to the record keeping, though, it's always the most important records to keep are a set of records right before marriage. It's not really going to be relevant. You don't have to go to the beginning of when you started this account. You can go just if you got married on, say, August 25th, get statements right up until that date. And it even would be wise probably to do a screenshot on August 24th. But that's going to be that line of demarcation where the court, or if you're negotiating a divorce, people can see what was in there before the account. Anything else on record keeping?
I know this came up last year and we spent a little bit of time on it, and I think it's related to the record keeping. So the idea, if we go back to the 401k, right? You're working, you're contributing to a 401k, you get married, you go in, you take a screen grab on August 24th of what the balance of your 401k is. You don't need, well, you're probably not able to, but you're not going to go out and start a new community property 401k at that point. You have just taken a screen grab and say, okay, my 401k is worth $200,000 as of today. But you don't need to do anything additional on top of that, even though there must be some commingling going on at that point on August 26th when you get your next paycheck and make your next contribution. But when you're talking about record keeping, it's just making sure that you know right before you get married what you already had. Is that right?
Yes, and it probably is a good idea to then save the statements after that. So to Sarah's point, with a 401k, your employer isn't going to allow you to, they're not going to have some other 401k for you to contribute. So once you're married, those contributions are community. And for the most part, let's say that account has $200,000 on it before marriage, and at the point of divorce, it has $400,000 in it. I've mentioned, I think, the word tracing, and what tracing is taking each individual piece of property and tracking it through to see what it is today. But as you can imagine, it's very time and cost intensive to trace, each position or each stock that was in your 401k the date of marriage, and trace it through to the point of divorce to see what the increases in value were and the decreases in value and the dividends that were thrown off. Sometimes there's an account where it is worth doing that tracing, but usually what people do is just say, okay, it's 400 now, it was 200 then, we're going to call that 200 that person's separate property.
Yeah.
Even though that 200 may be worth more, it may be worth less right now. You'd have to literally look at what the portfolio was on the date of marriage, and that very rarely happens. But at least you preserved the balance that you had on the date of marriage. And let me also say about this, it does not having that statement, if you do get in the unfortunate position of going through a divorce, makes it easier to discern what is separate property. But it does not mean that if you don't have that statement, but you can find that information, that it has somehow become your community property. It is your separate property. I mean, that's the state of the law. It's a matter of having easy proof about it.
Got it. So not taking the screen grab doesn't mean you are giving up your claim to it being separate property. It just means that it's going to be harder for you to track down that information when you're sitting in your attorney's office and you need to find to prove it.
And I've just noticed, like, we all have that, even 15 years when I was practicing, people would come in with their paper statements, or they would go to their financial institution and they could order all these paper statements that were on microfiche or something. But now nobody's saving those.
Yeah.
So it's just harder now to go back and establish if you didn't save something.
Yeah. We have a couple more questions that have come in. Do you have on this topic? This one might be a little bit more philosophical. Maybe you can shed some light on it. Why is my investment house rental income community? What if the money was deposited in my account only? Is that still community money?
Yes, it is a little philosophical. So somewhere along the line in the legislature, it was decided that increase in value of separate property stays separate, but that income that is thrown off from separate property is community. And I think the idea is that during the marriage, any income that gets generated is community. And it really doesn't matter. So let's just say that your income, you take your paycheck, you and your spouse keep completely separate finances. You earn money, your paycheck goes into a Wells Fargo account in your name only. Having an account just in your name does not change the character of the money. And again, that cuts both ways. And I still more typically see, for example, a husband who tries to keep a real tight rein on the finances and puts all the accounts in his name, and may think, well, I've earned it, it's my money, it's in an account in my name, and that it's not, it's community if it was earned during the marriage. Unless you've altered that by agreement. So that's where we get into prenups and postnups.
So yeah, we're kind of going down that road for sure. Oh, and I'm sorry to interrupt. I think on the same, there was another question, a follow-up similar to that. Do dividends in a Roth IRA count as community income?
Yes, typically that would be income. But when something is so nominal that it doesn't warrant tracing it, it usually doesn't get traced. So for example, right now I have a case where it's an investment account. It's really easy to see what the dividends were. And the dividends are reported on a tax return. So we can see exactly, $5,000 in dividends were paid last year. But you wouldn't normally see that with an IRA. And it's yes, so technically the dividends are community, but at the point of divorce, it's really almost never the case that it's worth going back and tracing every dividend to parse out what usually is a small amount of community property.
Yeah, so I think that even though the follow-up question was because the dividends on a Roth IRA, the dividends don't show up on your 1040, right? And so from a tax perspective, that's true, but from a legal perspective, technically those dividends are community property. And there's not a ton of overlap between like what the IRS considers something and what like the community and separate property laws are in Texas. Those are kind of two separate sets of instructions, I guess, or two different sets of laws.
Yes.
But any income, whether you earn it, whether it's your property or whether it's your stocks or your investments, any income, you're telling me it's community property.
Yes, unless you've altered it by an agreement, by a binding agreement. Yeah. Which I'm going to go through that because I'm seeing more and more people, and really I've seen a lot of people during COVID looking at doing prenups and post-marital agreements to discern their, who owns what and what's going to go to whom in the event of a divorce.
I'm going to mute myself then and let you kind of launch into that next stage. That sounds like it's the next logical place to go.
Well, there's one other thing I want to say that kind of touches on this, issues that can come up when you're not sure about separate and community, and then I'll go into prenups and postnups. So the other one that comes up a lot has to do with home ownership. Because Texas discerns what is community and what is separate by what's called inception of title, which is just a fancy way of saying, when did you get this? So if you got it before marriage, the inception of title is before marriage. So in the example of a house, I've also had a lot of people, this is very common, everybody, and some of you may even have this situation, where even say right before marriage, a couple says, well, let's buy a house. I'll buy it because I have the money for the down payment or my credit's better. And you buy a house and then you get married a month later, 2 months later, and then you've lived in this house. It's your family home for 10 years, 12 years. And unfortunately, you're in a divorce. And I have so many people come in and say, well, that's our house, right? We're going to sell it and divide the proceeds, or that person's going to have to buy me out. And I have to say, no, it was acquired by the wife or the husband right before marriage, and that is that person's separate property. And the increase in value is their separate property. So, and this is a little hard to understand. But all that there is usually with that is what's called a community reimbursement claim, which means that, let's say the mortgage on the date of marriage is $200,000. And then the people get married a month later and they're using community income to pay the mortgage payment. And then it's time for a divorce. The community, which is both people, has a claim for the reduction in the principal of the separate property debt. So let's say during the marriage, they paid off $100,000 of the mortgage. The community would have a claim for that, and any one person would only have a claim to half of that. So it's very disappointing. And let's say now the house is worth twice as much what it was, to find out that that's all you're going to get from what you've considered to be your home. You also can't force a sale of the home because it's the other person's separate property. So I know, home is usually many people's major asset, and it's very discouraging to people to learn that all their efforts won't be counted at the point of divorce as something they can be compensated for or recoup. And I've seen a lot of people, especially with interest rates really low now, people will even multiple times over the course of a number of years refinance a separate property house, and the other spouse has to sign off on the real estate documents. And many people will say, well, we refinanced and I had to sign all that, so I think I'm now on the deed, or it's somehow been deeded to me. It's not. It is not. So my strong advice, if you're in that situation or entering into that situation, is to have a candid conversation about your spouse, or with your spouse or your future spouse, about I want my name on the deed of the house. Especially, I can't tell you how many times I've seen really the house is purchased really close in time to the wedding. And it is completely understandable that people think of it as, well, it's our house, we're buying this. Because a month later, they're contributing to the mortgage. So,
the date of marriage is incredibly important, it sounds like.
yes, it is.
It doesn't matter if it's close to the date of marriage or what the intentions of the parties were.
Right.
It
could be the week before. I've seen people close on a house, and if only one of the spouses is on the deed. Here's the other thing that happens. Often you'll have one spouse on the deed, but both partners on the debt, which is what a refinance does. All that does is add you to the debt. It does not add you to the deed of trust about who owns the house. So I've probably seen twice in 26 years a situation where spouses intentionally put the other spouse on the deed. And they were clear, like, I'm conveying half of the interest in this asset to you. So you have to actually proactively do that. Refinances don't do it. As Sarah said, people's intentions don't do it. I had a mediation a week ago, this exact situation, and one of the parties, their domain was the house. The person had decorated the house, the person was a homemaker, the person had done everything related to the children. They had a very traditional division of labor. He was the financial provider, and she learns that because the house was purchased a month before marriage, that she has no interest in the house. And so she was also the party who needed to move out. And frankly, it was very devastating, because it wasn't just a house for this person, it it was what their job had been for 20 years. I mean, it was like getting fired from a job you love and having no claim to it anymore. In that particular situation, it happened to be the husband. He was kind enough to say, I know it's my separate property, but I am going to split the equity with you. But that was like, you are at the mercy of that other person. And that is the one time I've seen that happen in 26 years, is where someone's like, I know, that person did honor the intent of their kind of, their relationship agreements. They weren't legal agreements.
Yeah.
And that was kind of that person. But it's just been devastating for the other person to lose their domain, where they've worked for 20 plus years. In fact, it was hard to take things out of the residence because it felt like dismantling what this person had put together. So that also is something I see so often, and I would like more people to not be in that situation.
Yeah. And as I suspected, as you shared more of these details, we've had a couple more questions come in about some of these issues. I think a direct follow-up to what you just mentioned. There's a question: what happens if you are added to the deed many years after the purchase? Does that mean that it becomes community property, or does it become your separate property, half one spouse's separate property and half the other spouse's separate property?
Yes, what it essentially is a gift by the one spouse to the other. So a gift is separate property. And so it makes the house technically one half each separate property. It doesn't convert it to community property, but most people treat it like it's community property. Or the other thing you can do is, with a post-nuptial agreement, specify that we are converting the separate property asset to a community asset.
And then we have a question that goes a little bit in the reverse. The question is, so when you have a separate property house, but sell it during the marriage, does the money you make on the house become community property?
Okay, that's a really good question too. What's called a mutation of separate property is still separate property. So when you take the equity in your house and you convert it from equity in a house to dollars, those dollars are separate property. But that's where you get into commingling. So it's very common, someone sells a separate property. The most common scenario, honestly, is someone sells a separate property house. Let's say they net $100,000, and they'll put $50,000 into a down payment on a new house that they do purchase with their spouse. And then they take the other $50,000 and they buy furniture and art and draperies, or they go on a vacation, or they just use that other $50,000, or they put that other $50,000 into a bank account. The $50,000 that you can show directly went into the closing on a new house is pretty well preserved. At the point of divorce or at the point of the sale of that house, that person has a separate property reimbursement claim for the $50,000, because it's pretty easy to track that the $50,000 came from the separate property house. What you cannot trace is the other $50,000 that went to the trip to Hawaii and the couches and whatever. That's just gone. I mean, you can't really, or you put it into a checking account that you and your spouse continue to put your paychecks into, and it's just, again, the legal term is hopelessly commingled with community money. It's spent. Did that answer that?
Yeah, Melissa, let me know if there's a follow-up on that. A couple other ones. Let's see. What if you move to Texas from a state that assumes separate versus community, or moving to Texas, or maybe.
Oops. I don't know if you can hear or see me, but you're frozen right now, Sarah. Okay, you're back.
Sorry, y'all.
That's okay. I didn't catch that.
Sorry, I was frozen. I'm like, oh, by the way, if I freeze and go away, give me 5 minutes to get us back up and running.
Okay.
Or give me 5 minutes to come back online. What impact does moving to or from the state of Texas have on this discussion?
Okay. So, I am actually licensed in Illinois too, but I haven't practiced there in 29 years. So, each state has their own family law or their own divorce law. And you also have, each state has its own waiting period before you can file for divorce. So in Texas, for example, you have to have lived in the state of Texas for at least the 6 months before you file for divorce. So in some states it's a year, a lot of states it's 6 months, some have a lesser amount of time. Some states require you to be separated for a certain amount of time before you can file for divorce. The law of the state that you file in is the law that applies. So if, this is fairly common too, let's say a family moves from California to Texas. As we know, there are a lot of people from all over the place moving to Texas, and they've been here for 6 months, and then someone files for divorce. It's not going to be California law that applies. It's going to be Texas law. And literally, Texas and California are kind of at opposite ends of the spectrum in terms of how they deal with issues like alimony. So that, you'll have a lot of people move here because there's no state income tax, for example. But someone from California who's been here 6 months, again, this is going to sound stereotypical. It is still generally women who need alimony and men who pay alimony if they're required to. So you move to Texas and you learn that we have a alimony statute that's so narrow that you're really probably going to get almost nothing. Whereas in California, the standard is to be kept in the lifestyle that you become accustomed to. So the short answer is Texas law is going to apply if you meet the jurisdictional requirements and the timing requirements, even if most of your assets were originally acquired or accumulated somewhere else.
Looks like we have one more question kind of on the community and separate property issue. Can you buy a separate property asset after marriage? Like use community or separate money and only have one person's name on a deed and have that be separate property?
Having one person's name on anything, a bank account or a deed for real property, does not make it separate property. It's that fancy term inception of title, which just means when did you get it? And if you got it during marriage, even if it's only your name on it, it's still community, which is why financial institutions in Texas, for the most part, don't let real estate transactions go through unless, if you have a spouse, your spouse is going to sign in some way, because they know that a spouse really can't acquire real property on their own and have it be separate property.
Mm.
but you can make an agreement about really anything.
Mm.
So you could either, and I'm getting there, alter it by either a premarital agreement or a postmarital agreement to specify, say it's a postmarital agreement, to specify, I'm buying this house with this money, it's my separate property, and you can do it that way.
Yeah.
But you have to have a written agreement with your spouse to either convert separate property to community or community property to separate. Same thing with debt.
Do you want to go into some of those agreements, the pre-nuptial agreements, the post-nuptial agreements, just some of these agreements you've been talking about? This is probably a good segue into that.
Yeah, and I'll come back and pick up a discussion about alimony if people are interested in it, and child support, and also just the divorce process. But probably for the reason that a group like this even exists, I'm seeing more people want to do premarital agreements and postmarital agreements. So what a premarital agreement does, obviously, is before marriage, it's a written contract that's negotiated and signed by both of the people that are about to get married. And in Texas, and well, I really can't speak for other states, but in Texas, you can make a contract before marriage that alters these kind of rules about separate and community property. You can also make sure that you've memorialized what is your separate property. And often people, what I'm seeing more of now, when you have two professionals, they're also saying in those agreements that we're going to alter the rule that our earnings become community when we get married, to say we're not going to have any community estate. My earnings are going to be my separate property. Your earnings are going to be your separate property. That way you can continue to contribute to your 401k, or use your separate funds to buy whatever assets you want, including a house, and it will remain separate. Some things that are really important about doing that are that it's an arm's length transaction. You hear those stories about somebody being presented with a premarital agreement the night before the wedding. You don't want to do that. It's basically, it's a very business-like process of negotiating before marriage what's going to be community and what's going to be separate. So a lot of times these agreements will just memorialize in a schedule what somebody owns. So it would list out, this house, this bank account, which is really just a statement of the law, but it is a way to have effective record keeping. To say at the point of marriage, these things were my separate property and these things were your separate property. And then from that point forward, you may have a community estate. Moving forward, you can set out how much each person is going to contribute to a household account, for example. You can set out what would happen in the event of a divorce. For example, you can say any community assets will be divided equally. So you take that issue off the table. I've seen people say, we're not going to have any community estate except if we buy a home together. And if we buy a home together, that will be our community property. And if in the event of divorce, we will split that equally. So that is a premarital agreement. And I will say, I've seen more and more young professionals without children being interested in those kinds of agreements because they do have assets. And I've seen, so, my job as a lawyer is really to advocate for the person I'm representing. I've had many of these, really the best way to do it is to have each person have their own lawyer, so it's very arm's length, and to have it be at least some kind of negotiation. That way you have representation, it's signed in sufficient time before the wedding so that nobody can complain that they were under duress or they didn't understand the agreement. It's a business-like contract. And I've seen, honestly, I think the benefit of going to a lawyer to talk about it is that, let's say you're a young professional, you're 35 years old, you're getting married, you plan to have children, but you really don't yet have the benefit or the disadvantage of seeing what can happen to relationships over a long amount of time. And so I will talk to that person about, well, what if you do have children and you decide you'll want to stay home? I've heard people say, like, that is not going to happen. And, as we all know, going through life, there are a lot of things that we think are never going to happen that happen. So it's just bringing up a lot of what ifs so that someone can at least think about them before they get married instead of when you're in the situation. I mean, we can't talk about every possible contingency, but there are a lot of things that people haven't thought about that, and I wouldn't have either. I mean, even as a divorce attorney, I've just done this long enough that I've seen how things turn out 25 years later, when your kids are grown, or, those kinds of things. So it's just some pre-planning in the event of something that nobody wants to have happen in their life generally. So that's really a prenup. And I think I really see two types of prenups. There's one type that's really simple that just says, this is what I own now, and this is what the other person owns now. And then there's a type of prenup that says, we really don't want to have a community estate. My income's going to be my income. My retirement's going to be my retirement. So those are sort of the two general baskets I usually see. I've seen more, I've had more calls about postmarital agreements since COVID than I probably have had in the last 4 years before that combined. So a postmarital agreement is it's the same thing as a premarital agreement, except you're already married. And you may be wondering, why would anybody want to do that? And so why people want to do that is there are a lot of people that actually, they really don't want to get divorced, but they're not able to get on the same page with their spouse about monetary issues. Or, for example, I did one where the wife inherited money and then she wanted to keep investing in real estate. And as she did that, those houses were community. She was able to do the first one with some separate funds, but then she wanted to keep going with her own income. And her spouse, she was not willing to stay married if all of that investing was going to be community property. And so, to be blunt, it's honestly people saying, like, I really don't want to get divorced, but if we can't carve out something that's mine, that's separate from yours, divorce might be my only option. And I think I've been, like a lot of us, all the various different things that are happening because of COVID, I think I'm getting more of these calls because people are at home, stuck together. They're spending a lot more time with each other. They're rethinking their lives and their relationships. And it's a way to not get divorced, but have a partial or full financial divorce, if that makes sense. Or it's a lot of them do end up as a divorce. It's in the process of negotiating it, people may realize really what I do want is a divorce. But I'm seeing people wanting to do postnups as opposed to getting divorced for things like preserving their health care. I mean, it's a terrible time right now for somebody to try to go out and get a job. So if let's say you've been at home with children for 10 years and you're going through a divorce right now, I mean, it's hard enough having been out of the workforce, et cetera. Now it's like, well, where would you get a job? So some people are doing postnups to preserve healthcare and to just preserve other financial interests without moving to the point of a divorce. I think it's, it's scary economic times, and people don't necessarily want to divide everything they have, if that makes sense. If I need to explain that more, just let me know. But it is a way to you can convert with a postnup. You can convert community property to separate. You can also convert separate property to community. So that house example where you might learn, wow, I've invested all this time and money and I remodeled the kitchen, and you realize it's not your house, you can convert that separate property house to community or the other way around.
What do people have more specific questions about prenups, postnups? I think that was a pretty good overview, but if anyone has additional questions, go ahead and plug them into the chat box. And also, I think we are probably a group today that if you wanted to unmute yourself, and if you have a question that it's just going to take a while to plug into the chat box, if you just there's a way to raise your hand. I don't really know how to do that, but if you just wanted to unmute yourself, I think we probably have the ability to do that today as well. One question that came in, do both individuals usually use their own lawyers when creating a postnup?
Yes, generally. And that is the smarter way to do it. So even if you're the one that really wants the postnup, it's preferable if your spouse has a lawyer too, because it keeps it an arm's length transaction. These agreements, once they're signed, are very difficult to get out of. And the only two ways you can get out of them are if you prove to a court that the agreement's unconscionable, which means it's just so wildly unfair that I've never seen one get turned over for that. The other one is you have to prove that you didn't sign it voluntarily. It's really difficult to prove that somebody did not sign an agreement voluntarily if they've consulted with their own lawyer. So usually the agreement will say, I waived consulting with a lawyer, or it will say, I did consult with a lawyer and this is who the lawyer is. And there's all this language about, I've read this, I understand it, it's voluntary, I'm not signing it under any duress. So the better practice is to have two lawyers for that reason, just because, I think most people, if they do a pre or postnup, hope that they're going to take that document and stick it in a drawer and never have to pull it out again. But if you do have to pull it out again, you want to make sure that it's enforceable and it's not going to be challenged.
Yeah, I mean, and certainly I think as being part of this group, also in my line of work as an advisor, and I'm sure, Catherine, you've maybe come across this too. In talking about this really sensitive issue, I feel like a lot of times one of the spouses or the future spouses says something to the effect of, I'm not in this for the money. And so either refuse to hire their own attorney or just sign whatever is put in front of them. Don't do that. Don't do that. The whole group is like, don't be a martyr and fall onto this I'm only in it for love spiel. I mean, we all need to be realistic and preserve ourselves and our friends and our family. and just hire a lawyer, right? And it just, like Catherine said, it can be very business-like. This is kind of the business end of being in a relationship, the creating of the community estate and the, having homes and families and whatever that is. So I hope that if one thing came out of this group, I hope it would be more people hiring attorneys and signing these and negotiating these agreements instead of just signing what is put in front of them. So
yes, because it's not always the case that someone is not in it for the money, but that's usually not why people are getting married. And it doesn't mean that you are in it for the money to do one of these agreements. It's just that, and I see this less with, say, older couples who have kids. This is a second marriage or a third marriage. They get it. Younger professionals are, like we all were when we were younger, maybe just unaware of the trials and tribulations ahead in a relationship and just in life at that point when they're looking at getting married. So it's just, I think, a good idea to think through some of those things at that point in time, because life has a lot of surprises. I love the saying that life is what happens while you're making other plans. So when you're in, a young professional planning a wedding, probably one of the happiest times of your lives, of course you don't want to think about getting divorced in 10 years, or what if you have a disabled child, or some of these other topics that people don't really want to think about. But I think it can be really helpful in the long run.
Catherine, we have a couple questions, two different questions that have come in that maybe deal with more complex issues. Would you mind hearing the question and then seeing what insight you can offer
Sure.
to a couple scenarios that came in? The first one is, what if you own a home separately before your marriage, but years into the marriage, you put your spouse's name on the deed? Your spouse then passes away. He has children from a previous marriage. He dies without a will. Do you know what would happen to the house?
Let me say this one thing. I don't do estate planning and probate work, but there's a big intersection between the two areas of practice. So if his or her name is really put on the deed, again, a lot of times people think they've done that, like in a refinance, and they really haven't. But let's say they very intentionally, he or she conveyed half of the interest in the house to the other spouse, and the spouse dies with or without a will, but half of the equity, it belongs to the estate of that deceased spouse. And again, I want to be a little careful not to drift into a practice area that isn't mine, but without an agreement, a surviving spouse has what's called a life estate in the house. So it does not mean that suddenly you're getting kicked out of your house by your deceased spouse's children. If they're the beneficiaries of his estate, at some point they will be entitled to half of the equity, but not while you're alive. And same thing with your beneficiaries. So it's not my area, but it's a good reason to have a will that spells that out. But without any other agreement, the surviving person has a life estate in the house. You get to continue to live in the house for the rest of your life, unless you decide otherwise. And then at whatever point in time the house is sold or the equity otherwise divided, his beneficiaries would be entitled to half of the equity. It doesn't matter that it was your separate property. because once it is converted to something else, it's not.
You don't get
It's
to change it to, you don't get to give away, or not give away, you don't get to reassign half of your separate property to someone else and then take it back after the person passes away.
right. And if you convey half of your interest in a deed to the other spouse, what it is half of the equity belongs to his or her separate property estate and the other half belongs to yours. It doesn't make it community either unless you have an agreement.
Interesting. Okay, so one other one. What about when remarried parents have their names on joint accounts with the children? Can those accounts get pulled? Are those accounts considered, I guess, would those accounts be considered community property? Or it sounds like two people, let's just say a second marriage for two people, those people have children from a previous marriage and have joint accounts with the children. Are those considered community?
It really depends on the source of the funds. So I've seen a number of people have an account with their mom or their dad on the account as well. But if it's really the child's account, it's not going to be subject to division. But if it's
really
the parent's account, right. Like, right now, I'm not married, but I have a daughter. She's now almost 19. You have to be on their account when they're minors. I just haven't taken my name off. But really, it's her account. It's not, it might be different if the account is really the parent's account and they're putting money into it. But what that would be is a gift. So that would be a gift from the parent to the child. And in a divorce, sometimes people try to make a claim like, well, he gave his daughter $500 a month of our money. I want that back. A court is not, unless a gift is really someone perpetrating a fraud on the marriage, they're not going to want to claw that back into the community estate. People have some, discretion about what they give to their children. Does that make sense?
Yeah.
Yeah. Different if it's, he sold this huge business and put all the money in his daughter's account. That's different. Then yes, you might be entitled to that.
One other one came in. I think this is kind of a nice, maybe we're kind of at the halfway point here. So I think this is kind of a nice pivot. And then I know you have some additional topics you want to cover. But the last question that came in so far is, what advice should we be giving to our daughters or nieces who are potentially getting married at a time when they have little or no assets to prepare and protect themselves for the future and the unknowns that might happen?
Okay, that's a big topic. So a lot, this is going to come from my biases I've developed. Both doing mostly from the work I do, also from going through a divorce myself, and I have a daughter, and I also have a teenage son. So I have both. So I'll just give you my answer and we can go from there. All of this is like personal preference, right? But I would not advise changing your last name, which really is not a financial issue, although it just, nobody thinks they're going to get divorced, but I've just seen a lot of people, more typically women, who, their name ends up super convoluted because there have been a couple divorces and kids but that's personal preference. with what I've seen in divorces with women who've been out of the workforce for a long time, I personally would tell my daughter, don't step out of the workforce. It's just, it's so difficult. And again, this is not any kind of criticism or of people staying at home, or it's just, you never, I just see still more typically it is daughters, young women staying at home with children. They never recover that in, for the most part. You don't recover what your earning capacity would have been. And I know there are a lot of things to consider. But if someone has a profession, even, it's very hard to get back in the workforce. And then you've lost, say, 11 years of being in the workforce and saving for retirement or well, just, having the earning potential that you could have had. I would also say, have those conversations about, what if we do this? What if we do that? What if we have children? How do you feel about a situation where both parents are working? How do you feel about someone needing to stay at home? I think just having more awareness would be important. I would also say, save for retirement. If you do stay in a job and you have any kind of 401k or your employer matches, don't just depend on your other spouse for your financial well-being for the rest of your life. If they're thinking of moving into someone's separate property residence, I would absolutely say I want to be on that deed. And I think that goes both ways. That, I would say that to my son as well. I think if you're going to be both contributing, or be clear, just try to be clear about what that means if you're not on the deed. What else, Sarah? Can you think of other?
I mean, I think those are great. I mean, absolutely. I'm gonna, I know, and it's not trying to be controversial. I think it's, the advice that I would give to my daughters as well. And I think where I see women avoiding some of these financial pitfalls, the earnings question is a big one, right? That being in the workforce or being out of the workforce is huge. It's huge. So, whatever decision you're making about staying in the workforce or leaving the workforce, be really, really mindful about what financial impact that has on you. And I would say, for women, the way you get wealth is largely you earn it or you create it through investing, right? So if you do give up earnings, I would say make sure you have accounts in your name that you are investing. Make sure that your household is creating a community estate. Back when I first moved to Austin, my first job was in a law firm. That was the first time I met Catherine, by the way, 20 years ago or however long it was, when she was an attorney and I was a legal assistant. But getting divorced and thinking you are splitting a community estate and no one over the course of the marriage has saved or invested any money, they just spent it all, both parties, or maybe one party, but usually the household. I mean, you haven't created any wealth to divide. So certainly I think being part of a marriage, the creation of wealth and having a huge part in that, and being intentional about creating wealth so that there's something there if you do end up being divorced. And also, I mean, coming back to just being really, really mindful about whether you stay earning money or if you step out of the workforce, because it's so hard to come back. Still.
And this is also really important. I want more women to understand about alimony in Texas. So I'm going to tell you the specifics about that, and it really fits into this question because, typically it is two partners, building joint wealth, or usually if one person is at home, a lot of the thinking, of course, is, I'll be the one doing this part, and that will allow you to go climb the corporate ladder, do everything you need to do with work and earn money for our family. What people don't know, and it doesn't look like it's changing anytime soon, is that alimony in Texas is so narrow. So alimony is a post-divorce monthly financial payment. It's not child support. So it's, and in Texas, it's meant to be rehabilitative, which means to get that person back in the workforce. So the entire intention is you are going to have to go back to work. In fact, you're not entitled to even ask for alimony unless you can show the efforts you're making to become gainfully employed. So it's supposed to be rehabilitative. It's supposed to be for the least amount of time and the least amount of money. And the court is supposed to look at the property division and consider if that spouse can meet her, and I'm going to say her because, well, I'll get to that in a second, but her minimum reasonable needs. And minimum reasonable needs doesn't mean the way they've been living. And so and this is important, let's say the family has accumulated wealth. Let's say the total estate is worth $400,000. Each spouse can anticipate receiving at least $200,000, 50% of it, to our daughters and sisters. And, I wouldn't want my daughter in a situation where she has to, she's 50 years old or something, or 45 years old. She's been out of the workforce. Now she's learning there's not going to be alimony, and she's expected to live on her property division. So let's say the property division is the $200,000, and let's say $100,000 of it is in a 401k. I mean, that's tragic when I see it a lot. When people learn, oh my gosh, my property division is big enough that yes, I could meet my minimum reasonable needs. I could get a little 1-bedroom apartment or whatever, but I don't want to, this is what we've accumulated. I don't want to have to spend it while the other person has their property division and their continued earning ability. But it's really, honestly, it's also something the guys should know too, is that if you're, going to take this on, be accountable. That's what I would tell my son is, as Sarah said, if, make sure you're accumulating enough for both. What does happen a lot is I do see, honestly, most people are good, kind people. And most of the time, honestly, the male clients I work with, even though a court would never order them to pay alimony, they will voluntarily do it. But you don't want to count on that either. And because the statute is so narrow, what I usually see, what is usually considered generous, and is I've maybe had one woman in 29 years pay alimony. So this really affects women more. So I'm not saying it to be sexist. It's just the people who end up needing alimony are women. Is that what's considered generous because of our statute might at the most by agreement be 2 to 3 years is what I typically see. when I see someone who's willing to do it for 4 or more years, I mean, that's considered way outside the realm of what I would even say most lawyers would recommend somebody do. So that's pretty terrifying. It's a terrifying situation more for women. And the other thing that was really unfortunate on top of our statute being so narrow is that I think 2018 was the last year that alimony was deductible. So the way that we meaning divorce attorneys, the way we would encourage the payment of alimony was to say it's a dollar for dollar deduction right off of your income. Because essentially what it did was shift, say, someone taking that income and paying it a 30% tax bracket to the wife, ex-wife, who's at a 10 or 15% tax bracket. It just shifted the taxing burden. It's so following 2018, it's no longer deductible at all. So that incentive has gone away, and because alimony, it's women who need alimony. I mean, that was pretty devastating too, because we don't have that tool anymore.
Yeah, I mean, and certainly like this is, these are the reasons and this is the advice that it's why we have Catherine come back every year, and it's why this entire group exists, right? So that, as we're all going through life and learning all of these things and trying to prepare, the people around us to address all of these issues if they're well informed, right? We have a couple, in the chat box, a couple folks talk about like building credit, right? Kind of like the basic building blocks of being financially independent, right? Or being able to be in control of your own financial destiny, building credit, maintaining good credit scores, helping your children establish credit. All of those things all tie together for sure.
And on that point about credit, I also see a number of people at the point of divorce, and they've been an authorized user. Again, I'm not trying to be sexist, but it's just what I see. It's more typically she's an authorized user on his 3 credit cards and doesn't have a credit card. I mean, that still happens in 2020. And it surprises me, but it does happen. And so usually what we say is get a credit card, even if you're going through a divorce. Because in Texas, you're married till you're divorced. And so you can apply for a credit card claiming the family's income. Even if you're separated, if you're still legally married, you can say, our household earns whatever it is and get a credit card.
Awesome. Great. Thank you so much for sharing that. I know
Sure.
you had a couple more things on kind of the logistics of maybe what actually going through the process of divorce looks like and what it looks like now in the year of COVID and strangeness. Would you mind kind of walking people through kind of the process, what their people in their lives could expect if they have to go through this process?
Sure. And do you want me to, I can do that first, or I was going to cover a piece about child support. I don't know if people are interested.
Sure. Yeah. That'd be great.
Okay. So unlike alimony, a person generally can expect to receive child support. The structure in Texas is that there is child support is calculated based on a cap of net earnings of $9,200 a month, which means if you have somebody who's earning a net of $20,000 a month, the child support is not calculated on the $20,000 a month. The max is calculated on $9,200 a month, and it's 20% of that for one child, 25% for 2, and 30 for 3, and so on. So that's sometimes that's very positive for somebody to learn, and sometimes it's very hard for somebody to learn. You know, if you do have a spouse who nets $20,000 or $30,000 a month, and you're learning that you're going to receive, you know, $1,840 a month for one child, that can be bad news. But basically, right now, so that amount based on that cap is $1,840 for one child, $2,300 for two, and $2,760 for three. And typically, that person who pays child support also covers the children's health and dental insurance. I'm seeing more and more of a trend where divorcing parents are doing an equal time possession schedule. And the courts really don't want to discourage that. I mean, it's considered in children's best interest. They have lots of access to both of their parents. And I think more working mothers are more in fathers who are stepping up and doing, you know, all the same kind of parenting, naturally want to have equal time with their children. That does not necessarily impact child support. So that's the good news, is that, you know, possibly if you had two high wage earners that earn very similar amounts and do an equal time schedule, they might, no one may pay child support to the other. But if you have someone who's been at home and the other person's making $150,000, or there's any kind of large earning disparity, that higher wage earner will still pay full child support, even though they have the children half time. And the trend with the case law is that the purpose behind child support, everything that, when you have a child-related issue before a court, the guiding principle is supposed to be the best interest of the children. And so the thinking, as we see more 50-50 custody schedules, we're seeing courts say more that what's in the children's best interest is that they have the maximum access to their parents' financial well-being in each household. So sometimes people say, well, why should I pay child support when my children are with me half time? Well, it's not the reason, and we're seeing more of a trend of this with the court, is that because it's not really necessarily in children's best interest to be, you know, in a $2 million house over at dad's and eating ramen at mom's, frankly. So I think that's a positive trend. I think it's positive that parents are sharing custody more, but also that that's not resulting in, again, more typically women not receiving child support. I've seen a lot of, during COVID, high wage earning, honestly, self-employed men trying to reduce their child support obligation, and the courts are saying no. Unless, I mean, it's different. I mean, if you're a W-2, you work at Dell, you've lost your job, you are unemployed, or you've been furloughed, or, you know, that might result. But if somebody, I had a case recently where he went from making like $500,000 a year to $250,000. Yes, that is a huge pay cut, but he's still making $250,000 a year, and he wanted to lower his child support, you know, to the mother of his children who earns like $28,000 a year. I couldn't believe someone even took the case, but they did, and the court said no, we're not reducing your child support. So yeah, I'll move on to the process, but if there are any other questions about child support, and that it may fit into the process part too. What are the cutoffs? Oh, eight, the I just saw that question. So it's the cutoff ages. It's the later of 18 or when they graduate from high school. So if you have a child who turns 18 in November and they don't graduate till May or June, it's through that senior year.
Great, I think we're good. We have about 24 minutes left. So,
Oh gosh, okay. All right, the divorce process. So first of all, you have to have lived in the state of Texas for 6 months. Then you have to have lived in the county for at least 90 days before filing. So if you were in Travis or Williamson County, you would need to be in Texas for 6 months and in Travis County, for example, for at least 90 days. The divorce is started by filing a divorce petition. It basically tells the court, this is who we are, I'm seeking a divorce. And it starts a waiting period ticking. So there's a 60-day waiting period before you can be divorced, but nothing happens automatically on day 61. And it's honestly, it's pretty rare in my experience to see people get through the whole process in 2 months. At the beginning of a case, there may be, we call it temporary, and what we mean is the temporary refers to while you're going through the divorce. There may be temporary issues that need to be addressed. So who's going to live where? How are we going to pay the bills? Who's going to pay what? What will the children's schedule be? Who's going to stay in the house? Those kind of things. That I feel like during COVID, more and more people are really working those issues out on their own. I mean, I think, they just are. I think that's good. More and more people are doing in-house separations. So I'm having more and more cases where people aren't separating by getting a separate apartment or renting a separate house. They're just saying the practical realities are, here, we'll go to separate bedrooms and let's try to get through this without having to get another residence. That has some upsides and it has some downsides, as you can imagine. So usually in the beginning, it's just kind of sorting things out for how people will operate as they go through the process. And then at some point, there's just pure information gathering, which ties back to the record keeping that we talked about in the beginning. It's gathering statements, finding out what the equity is in the house, seeing what retirement accounts people have, trying to discern what is somebody's separate property. So it's just information gathering. And one thing I will say to you people on the call and anybody else in your life that may ever go through a divorce is it's very natural for people to want to put the cart before the horse and think, okay, well, before I do this, we need to figure out what we're going to do with the house. Or like they kind of want to know how it's all going to turn out. And that can keep people really stuck. So one thing to know is you do not have to figure out every single thing about how it's going to work out to proceed through a divorce. Because we will figure it out. We will help. Divorce attorneys and other professionals, financial professionals, will help you and your family figure that out as you go along. But it's such an anxiety-producing life transition that it is normal as humans to want to know, how is this going to turn out? Am I going to be, a bag lady under the bridge or what? And most of the time, you're not going to be a bag lady. So at some point, it's the quality of the information gathering is really important, because the more informed your professionals are and you are, moving on to the next phase of figuring out how to resolve the issues it makes it easier because you're dealing with actual information. And once people have the information, many times people change their minds. Some people start out saying, oh, I know I can't keep the house. And then we do the financial information gathering and they can keep the house. Or conversely, someone will say, I've got to stay in this house. I will just, and by the end of the process, they're thinking, I really want to sell the house. So it is a process, and it takes steps, and a good professional will help you move from step to step and will want to have the information to give you the best advice possible. At some point, the issues get resolved either by going to court or more likely in a mediation or some sort of facilitated settlement. Even before COVID, over 90% of people resolve their divorce issues by agreement. And certainly now in COVID, I'm seeing a lot of agreements happen. I think people are becoming more pragmatic. We are doing everything by Zoom. So mediations where we used to all go to one place and be in a conference room, they're happening by Zoom. Court hearings are happening by Zoom. The judges are working really hard. If you can imagine, most of the judges are currently in court hearings on Zoom, probably 40 hours a week. I mean, they are having some Zoom fatigue. So if you go, so I always am very conscientious about what I'm going to bring to a court. I mean, before COVID, I didn't want to show up in front of a judge with, a ridiculous position. But right now, you really don't want to because, and I was telling Sarah, it's taking longer to prepare for those hearings because you have to have all of your exhibits. So anything you were going to show the court, you have to have uploaded to their equivalent of like a Dropbox. It's not Dropbox, but like a day before the hearing. So you have to be really prepared to even be ready for a hearing. And then you're with the judge, on a screen, just like we're doing, having to screen share your exhibits. So it takes a lot of preparation right now. So at some point, your case is resolved and you know what you're going to be living with in terms of your finances and your children. And then it's time for the attorneys to do the drafting. And Sarah might remember this. It can be a pretty frustrating part. I know it sounds strange because you've resolved your case, but I think by that point, people are so ready to be done. And it is very hard to understand why it's taking so long for the lawyers to produce the documents that make it completely done. But it just does take a while to dot all the I's and cross all the T's and get it in a shape to give to the court. Right now, at the end of a divorce case, we used to take our clients up to the courthouse and appear before a judge, and the judge would say you're divorced. Now we're doing everything by written submission, and different courts are turning around orders at different points in time. I think, again, like a lot of things in COVID, it seems like things are just taking longer or the process is somewhat slowed down. I did want to share, I don't recall talking about this much last year, but talking about collaborative divorce, which maybe at this point more people have heard about. But a collaborative divorce it is also a process like litigation, but everybody agrees that they're not going to go to court. And I'm seeing a big uptick in people choosing the collaborative divorce process to go through their divorce because it is very pragmatic. It really deals only with the set of circumstances that the family has to figure out to go forward. It is more easily done by Zoom than the court hearings. And it's just very focused. So for example, the financial issues, the way we handle it in a collaborative divorce is people just ask from the other side what financial information they need and want, and people just provide it. So it's just a more direct process than having to navigate all the rules you have to navigate about civil procedure or presenting evidence when you go to court. And I think it's just more accessible right now for people going through divorce. Anything else about the process, Sarah?
Yeah, any questions, anyone, on kind of what it might look like to actually kind of go through this? And of course, like if you have questions, reach out to, well, maybe not me, but you could reach out to me, right? Or Catherine kind of offline, right? Maybe to learn a little bit more. I know that, a lot of people get clarity by consulting with an attorney before they actually do file for divorce, maybe to learn more about the specifics of what it might look like, or for you personally, especially if you have, extenuating circumstances or just something you wanted to, get a little bit of clarity on before you know whether or not now is the right time to pull the trigger on something like that, or whether you want to wait or not do it at all. I don't know. So I think that certainly reaching out to a trusted professional when going through something so dramatic is always a good idea. But if y'all have any other questions, go ahead and drop them in the chat box.
And on that point, Sarah, I will say, if you have follow-up questions, call me or email me. Me and my colleagues, we often do have a consultation with someone, and it's just about, they are unsure about filing for divorce, they're not ready to file for divorce, but they want some education as part of their thought process. And many of those people I never talk to again, or I get a call a year later. So, and I know it's a scary call to make, but just know that really any good attorney is going to want to help you and educate you through that thought process. And it's not, so if somebody calls me for a consultation, it's not my role at all to talk somebody into a divorce or out of a divorce. It's just to be helpful and to educate, and then, be there if that's what is going to happen.
There's one other question that I think is really interesting. Maybe we can end on this. Lorena asked do you know of any countries or maybe other states where you think that the divorce process has better outcomes? Like, is there, and her follow-up, is there a more egalitarian way of getting divorced somewhere in the country that we could be inspired by, or be inspired to vote for ways to make the process more equal in Texas? So what are your broader views on how this process could work better? And I'll just say for women. I'm just going to throw it out there because that's who we're talking about here.
My dog just made an appearance. If she starts to bark, I'm going to mute and let her out, okay? Because she's got a loud bark. I think she's been napping up until now.
Yeah.
I don't know much about divorce in other countries or other states, but I have had probably 3 or 4 cases over time where there was a jurisdictional fight between California and Texas. And the reason for that is that California's laws are like the opposite of our laws in terms of alimony in particular and property division. And I really can't, I don't know if it means it's more egalitarian, but I do know for example, that in Texas, where alimony is supposed to get the spouse out working again and for the least amount of money and the least amount of time, you will often hear about in California, people get alimony orders for 10 years. And again, I don't practice it. Okay, hold on.
Here, I'm unmuted. So certainly, like while we're waiting for Catherine to let her dog out, which I love that the dog made an appearance. If you have any follow-up questions, go ahead and put them in the chat box. But I'll take this opportunity too to let you know that we will send out a copy of this video and also all of Catherine's contact information in our follow-up. So if you do end up having questions, we'll send that out in our follow-up email.
Sorry about that. Where was I? So
California.
Yeah, so I know the standards are very different, and I've had a number of people who end up, moving from California to Texas, and they're just shocked by the difference in the divorce laws, basically. So I don't really have other states to compare it to. I will say that I have had a number of child custody cases where somebody had a divorce order from a different state, and the divorce orders are, I'm not joking, like 2 or 3 pages long. And I don't know how anybody even figures out, like I had a client who their case was in Queens, New York, and I think it's just a function of the huge volume of cases, but their order was about 3 pages, and you couldn't necessarily really figure out what they were doing or who was getting what, and it's kind of a mess. So our decrees in Texas are very thorough, very detailed, and they're usually about 60 pages long. They're pretty lengthy. I don't know what would, in terms of making things more egalitarian,
So if we talk about like the alimony statute specifically, is that something that can change? Like, can someone introduce a bill in the Texas Congress?
Yes. It can be a matter of approaching the legislature. I don't remember. I know I was practicing for a significant amount of time before there was any alimony statute. Mm-hmm. We literally had no alimony statute, and it's probably older. Like if I told you, I think it happened in 2005, it's probably older than that. I'm just not really remembering when it happened. I could look it up if somebody really wanted to know, but it may have been 1995, but we were really late on that bandwagon in terms of our state.
And we did have one follow-up on prenups, just to go back.
And let me just make one more comment on that. The one thing that, and I don't know how, this is a big question. It is making things more egalitarian really it's going to be just in our society having probably, more and more women that are high wage earners, that have assets, that are, now, I probably have had, 10 among thousands of cases where it is the woman more in that, where there's I don't know if role reversal is really the way we would say it now, but but I think it will just take society advancing.
Yeah. Just one quick follow-up on the prenups, which I know you talked about earlier in the meeting, but there's a question on just kind of your thoughts as to the prenups that you've seen, whether you've drafted them, whether they've come through your office. Do they work? Do they kind of always or almost always hold up in court the way they're put together? Is it something that is worth spending time and money on?
To my knowledge, haven't had any that I've drafted or participated with get challenged. they're very difficult to get undone, very difficult. It's more common that I've had a case where it's the woman walking through my door, and years ago she signed a premarital agreement that, given their current circumstances, is very unfair. That goes to the, not thinking about, or, not processing through the things that can happen. It seemed fair when the person signed it. Now it's 12 years later, and when you map it onto their circumstances, it's not fair. So I've had a couple of those where we've tried to, it's really difficult to overturn them, but sometimes you can find things in the agreement that sound vague. And that's sometimes where there's an entree to challenge a particular provision. Or often, even though people have a written agreement, they're willing to do something else at the point of divorce, if you know how to negotiate well.
Yeah. Well, I think we are almost out of time.
They do work and they do hold up.
Yeah, good. I mean, I think this puts us at about 4:30. I just want to say thank you, Catherine, so much for these 2 hours with us. I know we're getting a bunch of thank yous in the chat box to you. This is always, I mean, we try to do this topic every calendar year for this reason, right? Like, it's just, making sure that people who were with us last year, the year before, you hear it again and you start to absorb it. And for people hearing it for the first time, that it's just, it's knowledge that you can tuck away, hopefully for future use, because it is so incredibly important. And we want everyone to have as much information as they can possibly have as they're going through life and making these really big, important decisions. So, I mean, I can't thank you enough. Again, to everyone in the group, we will send out Catherine's info and make sure that you have that. She's just always volunteered her time to come here and help us think through this big topic. So thank you. And
I hope it's been helpful, and I hope you all stay safe and well, and don't hesitate to contact me with follow-up questions or anything else that you guys might need.
Perfect.
Thanks for having me.
Thank you. And the Austin Women's Investing Group, we will have November and December meetings. So we're going to finish those up and the scheduling of those, and we'll send out invitations as soon as they're ready to go. So in the meantime, everyone stay safe out there. Let us know what questions you have. Our private Facebook group, if you haven't already, and place to exchange info as well. So hope to see y'all in November and December. Thank you.
Okay. Bye, everybody.
Bye-bye, everybody.